Hello, thank you for joining me. My name is Seth Harper, and as the title in front of you suggests, I'm going to be discussing the riparian rights held by Orange County with respect to the waters of the Santa Ana River, specifically as they were laid out in a 1969 judgment involving Orange County Water District. The Santa Ana River starts in the San Bernardino Mountains and stretches 96 miles to the Pacific Ocean. At nearly 100 miles in length, it is the longest river contained within Southern California, meaning the river does not cross over into any other state, it does not cross south of the border into Mexico, and it does not cross upwards into Central and Northern California. The Santa Ana River is considered a non-navigable water body and has more than 50 tributaries. These more than 50 tributaries, along with the 96 miles of principal river length, form what is the primary drainage system for a 2,650 square mile watershed spanning over 4 counties. Within that watershed resides approximately 4.8 million residents, or at least that was the approximate count in 2000. It is highly likely that every one of those almost 5 million residents within the watershed have some reliance on the Santa Ana River drainage system, be it for potable water, recreation, agricultural irrigation, or some other business-related water use. This is a blow-up of the map that was on the introduction slide. As you can see, the river does indeed stretch from the San Bernardino Mountains all the way down to the Pacific Ocean. Here, about 2/3 of the way down the river, is the Prado Dam. Everything south of the Prado Dam in the watershed is considered part of the lower basin. Everything above the Prado Dam in the watershed is broken up actually into two separate basins, the middle basin and the upper basin. But for all intents and purposes of this discussion, we can consider all of this part of the upper basin. Prado Dam and the reservoir behind it, Prado Reservoir, will play a bigger role later in our discussion. Now that we have a better geographical context about the Santa Ana River, let's get some historical context. Historians suspect that human activity around Santa Ana River dates back at least 9,000 years. Of course, the earliest activities would be those of nomadic peoples. An important event that occurred in Santa Ana River history is the 1847 flood of the Santa Ana River. It assisted in California's independence from Mexico by preventing a large force of Mexican troops from being able to travel northward from the Santa Ana River and attacking a smaller American troop that was located in Los Angeles. The following year, the signing of the Treaty of Guadalupe Hidalgo would cede California, in addition to other territories, from Mexico to the Union. In the same year, the first American settlements would be established around the Santa Ana River. Following these settlements, a big economic boom would take place around the Santa Ana River watershed. One specific person who was both of interest to and a beneficiary of the economic boom around the Santa Ana River is James Irvine I, pictured to the right. He's also the same man that the city of Irvine is named after. Upon his death in 1886, his holdings in the lands down in the area were turned over to a trust which held them and at one point attempted to sell them, but they were holding them for James Irvine II until his 25th birthday, which wouldn't take place until 1892. In 1889, Los Angeles County was split up and Orange County was formed out of at least a portion of what used to be Los Angeles County. In 1892, James Irvine II turned 25 and took possession and control over his father's land holdings. The Irvine Company was established 2 years later in 1894. Though the Irvine Company was primarily known for their cattle ranching, they would diversify and start getting involved with crop agriculture. And things would go very well for the first 5 to 10 years, but somewhere in that first decade, water tables started to recede. This led the Irvine Company to start becoming involved heavily in water management. One of the things that was noticed was that there was a lot more irrigation being utilized upstream, and this was resulting in more drought-like conditions downstream. Jumping ahead to 1909, the drought-like conditions ultimately would spur the formation of the Water Conservation Association. This group would attempt to try and fix the problem by spreading water through porous beds near the San Bernardino Mountains, with the idea in mind that doing this would help cultivate more percolation into other groundwater resources. However, these efforts, as far as Orange County was concerned, were not very fruitful, and Orange County's contributions would cease as they were not perceived as being beneficial to the county. Fast forward 2 decades to 1929, and the Santa Ana Basin Water Rights Protective Association's head, Paul Bailey, would produce a report discussing groundwater depletion. His report was a very, very strong wake-up call to agricultural interests in the area. Yet, Francis Cuttle, the head of the WCA, would push forward with water spreading activities. 4 years later, in 1933, Senate Bill 1201 would be signed into law, and the Orange County Water District would be formed. They were charged with the responsibilities of protecting Orange County's water rights, both with respect to ground and surface waters, as well as to the rights to flowing waters coming from the Santa Ana River. Those protection responsibilities also included ensuring the water was of sufficient quality to be used for the various purposes that water would be used. 8 years after that, the Army Corps of Engineers would finish Prado Dam. The primary function of Prado Dam was to be flood control protection for the lower basin, but it also had a secondary function as water reservoir storage for recharging the lower basin's groundwater supply. Prado Dam is still standing today, and it has a capacity of storing 362,000 acre feet of reservoir water. Now that we've gotten our bearing in the historical and geographical context of the Santa Ana River, let's take a look at the legal aspects of the Santa Ana River. In 1932, the Irvine Company, headed by James Irvine II at the time, filed a lawsuit of water users in the upper basin. The water users were still spreading water, and this was causing less than favorable conditions for water users downstream. Recall that the following year, 1933, Senate Bill 1201 established the OCWD. 3 years after that, both parties to the lawsuit would agree to have a study conducted by a panel of 3 experts who would check the general annual water flows of the Santa Ana River, and in investigating those, they would establish amenable quantities of water rights usage for both sides of the lawsuit. OCWD would actually intervene in the Irvine suit the following year, 1937, pushing more for resolution through arbitration, which James Irvine II really had no desire for. He thought it was a lengthy, drawn out, and essentially useless procedure. However, in 1942, a water spreading agreement would take place where there would be limits on how much water could be spread from the Santa Ana River, and it would also be the basis for establishing the rights that were allotted to the lower basin for stream flow in the river. In 1951, OCWD would actually file a lawsuit on behalf of the water users of Orange County against Four municipalities being the city of Riverside, the city of San Bernardino, the city of Redlands, and the city of Colton. 12 years later, OCWD would file suit again. However, this time it wasn't just the previously named four municipalities, it was with the intent of seeking adjudication for the entire Upper Basin. In 1967, the city of Chino would file an appeals suit seeking a writ of prohibition, and this would result in the 1969 judgment, which seemed to have pretty much settled all of these matters. With respect to the 1951 suit, which was filed against Colton, Redlands, Riverside, and San Bernardino, it didn't actually reach the courts until 1957 and was settled in 1959. The defendant cities had the rights to the same water usage that they had in 1946, and though they appealed this on multiple occasions, the final appeal was exhausted in 1961. In the 1963 suit, the result was that a water master committee would be formed with participation from all parties involved, and they would have an annual report regarding the conditions of water supply. Additionally, 42,000 acre-feet per annum would be guaranteed to OCWD, as well as rights to store recharging reserves in the Prado Reservoir. Additionally to that, the upper basin parties would be responsible for ensuring that the water that would reach the lower basin would be of such quality that it would be usable the same as water that was naturally flowing. This result would be appealed in 1967 by the defendants, leading to the 1969 judgment. In 1967, the city of Chino et al., the petitioners, as they were referred, which were the defendants in the previous matter, would file suit against the Superior Court of Orange County. One of the defendants in the original matter was the United States itself. The two primary concerns brought to the appellate court by the city of Chino and the other defendants were, one, can the Superior Court of Orange County actually adjudicate over a matter in which the federal government is a party to the defendants? Two, there was the question of whether or not the Orange County Water District had legal authority in order to file a class action lawsuit when itself was not party to the class of members in the case. In 1969, Judge Whalen, who presided over the appeals, ruled on the matters and said that given the criteria that in order for the United States federal government to be appointed a party of defense in a lawsuit, all parties must be known on both sides, and that since there were most likely parties on both sides that were unknown, no, the Superior Court could not did not have jurisdiction to try a case against the federal government. However, Judge Whalen did rule that given that the authority OCWD has is derived through statutes resulting from Senate Bill 1201, they could in fact file a class action lawsuit to which they were not a party. And what's more than that, they did not need to identify all members of the class action in order to file said suit. They essentially the U.S. government has the authority over when they will or will not be prosecuted. In order for them to be prosecuted, they have to be able to. Sorry, prosecuted may not be the right term there. That may be restricted specifically to criminal law, but they have the authority to say yes, you can sue us, or no, you can't sue us. But in order for them to do that, given that they are the federal government, they need to be aware of all parties of interest so they can make sure that whatever results from the case are applied as they should be to all parties of interest. Since there were parties of interest unknown, the U.S. government could not consent to being a party to the defendant's cause. Additionally, with the question of the class action lawsuits, the OCWD is granted the authority to manage the rights of water for the lower basin, and as such, they have the authority to file a class action lawsuit whether or not they are a party to it, in addition to whether or not they are identifying all parties to that class action lawsuit. It's one of the authorities granted them through the legislation that enacted them. So it was a win in one hand that the U.S. government could not be filed against in this case, but a loss for the city of Chino and the other defendants. Saved the United States government in the fact that that they couldn't prevent OCWD from filing a class action lawsuit. There was, however, the Judge Whalen, who presided, did, however, issue a writ of prohibition, but it wasn't exactly what was requested. It was a writ saying that there's going to, after the filing of the judgment, there would be a 90-day period during which OCWD, if they could get all parties identified, could bring suit back against the U.S. government, and that 90 days could be extended according to Judge Whalen's prerogative specifically, or Judge Whalen's court's prerogative, if you will. I suppose something could have happened that might have prevented him from presiding over a rehearing on anything. Uh, but essentially, if the OCWD did not refile in the lower court with a filing that conformed to the judgment that was passed down, the case would the prohibition, the alternative prohibition would be uh, expired, and it would turn into a preemptory writ of prohibition, and that would become absolute. So again, a bit of a win-loss on both sides there, but ultimately the idea is that it should work out for everyone's benefit because we're trying to make sure that water rights are going to be approved all around here. Um, Moving forward, the events of the Prado Dam and the Santa Ana River haven't come to an end yet. There's been a lot of advancement in things like one of the things they did with the reservoir was they put plants in there that would function to do what treatment plants would do. They would put agricultural plants in there to function in place of treatment plants at something around the nature of 1/10 of the cost. And so in this expansion, they now made it to where it was a natural treatment plant for the waters flowing through it. We've come to a newer issue in the last 5 or 6 years in that there's been a sediment issue. When you put up a dam, it creates a wall that sediment can't get through. So the sediment that would naturally flow down into the lower basin has been trapped on the north side of the dam. So that can ultimately lead to erosion, and it has. It's led to a lot of erosion along the riverbanks as well as further down because you don't have that sediment moving down and settling in and replacing sediment that the water is washing away to some degree. What they are looking to do is the Army Corps of Engineers actually made public notice in 2011 for a dredging project where they would go in and they would dredge the north side of the dam in the reservoir to pick up some of those sediments, go and drop them on the south side of the reservoir. Then they'd open the reservoir full bore, or open the dam full bore, and let the waters wash the sediment down so it could have some semblance of the natural occurrence. One of the problems they're facing with that, which I'm not going to go into too much detail over, is that they have the the Endangered Species Act to contend with. There's 4 or 5 different endangered species. Majority of them are birds. One of them is the Santa Ana sucker. One of the endangered species specifically is the Santa Ana sucker. One of the birds specifically is the least Bell's vireo. So those they have to go in with biologists and have biologists identify the different nesting areas. And as I understand it right now, they've established that there's a single strip that runs through the reservoir that will not or should not impinge upon the nesting of any of these endangered species, that they can go in and dredge and then recover the sediments to take and dump down the other side. Uh, it just finished the public comments phase last month. It was a public comments phase between the month of March and April of this year. I didn't expect that it would be so long. I mean, I have some understanding of how the administrative law side works in that regard, but I didn't expect it to be a anywhere near a 4 year process. Uh, but luckily there hasn't been any lawsuits filed with this respect, or at least none that I could find. And it's something that is being addressed before it gets into a litigious nature. And I thought that was a vast improvement over how things went during the 1900s with respect to Santa Ana. So, for any further information that you might like to learn about from this presentation, you can find all of it in any one of these sources. The very last one there is the notice by the Army Corps of Engineers, and reading through that, I was actually rather impressed with the amount of detail that they have to put into these public notice of activity. So anyhow, thank you for your time.